I got bad advice from an immigration representative and I left the country when I shouldn't have. What can I do now? Hi, I'm immigration attorney Jim Hacking, practicing law here in St. Louis, Missouri. We were recently contacted by a young lady who had overstayed her B2 visitor visa by several years. In fact, it was for 7 or 8 years. And she had gone to an immigration representative with her husband and asked the immigration representative what should she do. Now, at that point she was married to a U.S. citizen, and even though she had accrued 8 years of unlawful presence in the United States by overstaying that B2 visitor visa, the fact that she married a U.S. citizen meant that she could adjust status and that her overstay would be forgiven. That is, that if her husband filed an I-130 marriage-based visa petition and a green card application, and if the marriage was deemed legitimate by USCIS and everything else was okay, the simple fact that she had overstayed so long would not mean that the green card case would get denied. In other words, she could get out of the overstay status and into a lawful permanent resident status because she had married a U.S. citizen. But this immigration representative, whatever that is, gave her bad advice. The immigration representative told the lady that she should leave the United States and have her husband apply for her while she's overseas. Now, as my old con law professor in law school said, why is this exactly the wrong answer? The reason this is the wrong answer is because she could have adjusted status here. But now that she's gone overseas, she has that 10-year bar. And that is, she has a 10-year bar on returning to the United States because of the overstay. If you overstay by more than 1 year, you are then given a 10-year bar on returning to the United States. So it's actually a very sad situation where this woman could have gotten a green card and not had to have left the country and not had to be threatened with this 10-year bar. Now what she has to do is have her husband file for a marriage-based visa, and she has to file for a waiver for the overstay. Now the waiver should be granted as long as there's no other problems, but it's really going to slow down her opportunity to come to the United States. And it was really sort of a pointless thing. I hope she has some recourse. I hope she can go after this immigration representative. I don't even know exactly what that means, but it's a lesson for everyone out there that you really want to work with a licensed immigration attorney. You should check the American Immigration Lawyers Association, make sure that the person's a member. Some lawyers dabble in immigration law, and some people pretend that they're immigration experts. You definitely want to stay away from those people and to use an attorney who's in AILA and who knows what they're doing. And so we're going to try to help this lady out if we can, but like I said, it's going to be a much more complicated case than it wouldn't have been if she had just stayed in the United States and applied from here. If you have a case like this, if you are an overstay and have married a U.S. citizen and are wondering what your options are, I want you to pick up the phone and give us a call, 314-961-8200, or you can shoot me an email, jim@hackinglawpractice.com. We'd be happy to talk to you. Thanks a lot and have a good day.